Friends, today we have a very eminent speaker. I will say that hidden jewel in our profession. He's not speaking too much, but really his experience is really worth to be listened, and we would like to and love to listen and understand his experience. Welcome, Mr. Amit Bhasin, Chief Legal Officer and Group General Counsel, Marico Limited. Amit, welcome to our webinar.
Thank you, Dipti, and thank you for this introduction. I don't know whether I deserve all of it, but thank you for your kind words.
I see your profile. It's so much enriched with the experience. Really, you require to share your knowledge and experience. Professional colleague will love to listen to you. And I'm very happy that I'm bringing you as a speaker. With the people who want to know your experience, they can, get the knowledge from you.
Thank you.
Friends, his profile is big today, but I am not shortening his profile because I want everyone to know what he is and how much knowledge and experience he has gained. Mr. Amit Bhasin is a Chief Legal Officer and Group General Counsel for Marico Limited. He is part of Executive Committee of Marico Limited and is responsible for legal and corporate affairs function for Marico Group, both in India and international markets. Amit Bhasin is a member of Governance Committee of Marico and also leads corporate social responsibility function of Marico. Great. Amit has over 19 years of experience in corporate legal business partnering, corporate compliances, and governance. He has worked across organizations in consumer sector. Prior to joining Marico, Amit Bhasin was associated with Hindustan Unilever Limited, another giant, as a general manager, legal and corporate secretary for over 13 years. He has handled multiple roles and worked in several merger amalgamation transactions and corporate actions for Unilever, including the acquisition of GSK business. He was part of several global working networks for Unilever in the areas of competition law, governance, and compliance. Amit plays an active role in the advocacy efforts for FMCG industry and is part of several industry bodies. He is a member of FICCI FMCG committee and chair for FICCI FMCG committee for legal metrology and CCPA. He is a part of legal committee of Indian Beauty and Hygiene Association, executive committee member of MCIA FMCG User Council and chair for Chief Legal Officer Network India, WinMark. He has been recognized for his excellence as the best leading lawyer 2022 by World Intellectual Property Forum. Amit was awarded 40 under 40 Legal Rising Stars Award by Legal Era 2019. He is a law graduate and certified chartered secretary from ICSI. He also having a post-graduation certification in sustainable business from the University of Cambridge, United Kingdom in 2011. Welcome, Amit. Honestly, I know you since years, but I don't know you are having such a huge experience and knowledge and leading FMCG. Excellent. Really, I feel proud as a professional colleague. I'm telling you by heart, really feel proud. Your achievement is excellent. Thanks a lot for having time.
Thank you.
Friends, today's topic is takeover code. It's continuously every time since it has come or before that also. Several questions, confusion, when the takeover will go, when it is said that we have to intimate, when we have to reply to the rumors and newspaper, when the regulatory will take it as non-disclosure, when regulatory say non-compliance. It's always a question of confusion, especially when the growing industry, you intend to take over certain companies and it's in a very initial stage. And it's the most confidential information any business will not like to reveal, and still you have to reveal. It's a very delicate walk on the tightrope. All this will be really shared by Amit in his experience level, practical experience. We have none other, our Ms. Jasveen, who is going to present this. And friends, as usual, whatsoever questions, queries during the PPT, you can put it on chat box, so same will be answered by experts. And also, Amit, as and when you want to share your experience, you can interrupt and just share your experience. Thanks. Welcome, Amit. Now, I'll request Amit you to say a few words on the topic, and Mr. 2 minutes for you, and then Jasveen, you can start the presentation. Over to Amit, please.
Sure. Thank you, Dipti, and thanks for inviting me to this session on a topic which is a very, very interesting topic of takeover code. And I was reflecting, when we were students of the institute and when we were appearing for exams, I think this is a topic which would have bothered most to the students, because the practical side of this topic and what is there in written in the books is very, very different, right? And it's only when I must say, I was telling Mr. Bala as well, I must say that it's only when I handled the topic practically is when I was able to relate a lot to it, because what is written there in the takeover code, while you can go through it, you can kind of understand broadly about it, unless you have kind of handled the takeover in the real sense, unless you have handled an open offer, the nitty-gritties of it, the challenges around it is something that has to be kind of seen to be understood. So that's what I would say. So I think if I just want to comfort people and the students possibly who are joining this call to say that don't worry if you don't understand it, that you are not the exception here, right? So that's about it of the takeover code. But I think I must say that Sebi as a regulator has done very fantastic job of keeping in pace with the time as far as this regulation is concerned, and that's true for most of the regulations that Sebi has amended from time to time. When the whole takeover code started, the whole genesis of it, and just spend a little bit of time on why at first place this is there. I think in the first place it is there to say mergers and acquisition and corporate restructuring is a reality of the corporate world that is going to happen and that will always happen. The shareholders who have invested in the company have, while they invest looking at the company and its profile and the products and the future of the company, there is a big kind of a trust that the shareholders also place on the management and the philosophy of the management and what is the vision of the management and the promoters who are running that. So there is an attached sentiment to that as well. The whole purpose of takeover code is that as a shareholder of the company, if there is someone else who is suddenly kind of trying to come and acquire the company, I must know. As a shareholder, it's my right to know that. So that's one. Secondly, then there has to be an option that has to be given to me to exercise my choice, whether I want to continue with the new management or the new promoters who are going to come on now, whether I feel myself aligned to the vision of the new promoters or not. And then a simple exit opportunity, if I am not allowed, needs to be given, or if I think that I'm allowed, then I should be allowed to continue. So I think that it is based on a very simple philosophy of a shareholder interest. It is based on a very simple philosophy of transparency. It is also based on a very simple philosophy of, by the way, running business in the smooth way. Because if anybody and everybody can simply come and start kind of taking over the businesses, it disturbs the business continuity as well. So I think those are the key premises to my mind on which this whole takeover code is based on. I will, of course, Jasleen will cover the whole part about the provisions around it and the procedure around it. I just want to share my two practical bits on this. And both are from my previous organization, which is Hindustan Unilever, where I've spent substantial time of my career. I will give one example of what happened when Unilever decided to do an open offer for Hindustan Unilever, which was a subsidiary. And I will give another example of an international scenario, what happened and some of the governance issues around it. As I said, you have to kind of really experience this once this happens. In my first example, Unilever was holding around 52% of shareholding of HUL. They decided to come out with the open offer to increase their shareholding. It was a subsidiary company. I think the biggest challenge there was, how do you maintain this arm's length, and how do you ensure that the highest governance norms are maintained? Because what you are going to acquire from a point of view of Unilever, which was a substantial shareholder, they were just going to acquire additional shares of its own subsidiary, right? However, from a governance norms point of view, it was an absolutely independent transaction. And I feel proud that I work for a company like Unilever and Hindustan Unilever, because the way this whole transaction was executed, the Hindustan Unilever management was not even aware that Unilever is going to put a bid like this. And that's a very high standard of governance, because the transaction has to be dealt in a way that it is to be independent. So till the time Unilever made an announcement globally that we are going to come with an open offer, no one in local management, including the top management, was aware of this, right? And I think that was a big learning to me, that how this transaction has to be managed and how it has to be seen independently in a scenario where there's your own parent company is going to acquire additional shares. And I think, of course, then throughout the process, this arm's length, and throughout the process, this independence was maintained, as if Hindustan Unilever is a target and Unilever is a acquirer. And the principles that you would do in a case of absolutely non-related parties of the takeover code were managed throughout the transaction, which means information sharing was to the extent as it was required under law only, which means the people who were consulting Unilever and consulting HUL were very different. So it was absolutely independent transaction, and it was to be seen and great learning to see how governance has to be maintained. Now, this is not, by the way, written anywhere in the law, Dipti.
Right.
This is not written anywhere in the law that you should do it like this. But I think practically when you implement this, you understand the benefit of doing it with high level of governance, because then nobody can question that there is any kind of a undue information or undue interest that is being covered in this. So I think that's one example which I very close to my heart, and I think that's why it opened a lot about takeover code when I handled that. I think other one is not a Indian scenario, but it is a global one where Warren Buffett's 3G Capital and Heinz Kraft had given a bid to acquire Unilever globally. And again, this is a case study in Harvard itself. And we were discussing with Mr. Bala as well. Again, a case of takeover and the take of philosophies and how shareholder interest has to be protected. So Kraft Heinz made a bid to acquire Unilever. It was a proposal by them to say we will give cash and we will give shares to the shareholders. It was commercially not a bad option, by the way, from a shareholder point of view, but there was a mismatch of philosophy. And those of you who know 3G Capital and who know how companies acquired by Warren Buffett and all have worked, their philosophy is simple. Their philosophy is cutting cost, bringing immediate gains to the corporation, and that's how they deliver shareholder wealth. Whereas Unilever ways of doing things is more long term. It is more creating sustainable business. It is more about creating shareholder wealth over a period of time by bringing growth, by doing business more sustainably. So there's a difference between the philosophy itself. And this bid was rejected by the board of Unilever on these grounds, saying there is a cultural misfit. There's a cultural misfit with this particular company. We don't think the way Unilever is working for so many years, the new promoters are going to follow the same philosophy, and we don't think it is good from the business from a long-term point of view. And even in our Indian law, there is this whole provision of having an independent director's report to the shareholders at the time of open offer, which is the view from the board to the shareholder whether they should go for it or not. Now, it's a very big governance process where the people who are sitting on the board but are independent are giving a point of view to the shareholders of the company, saying whether how they should view this open offer, and whether there is a cultural fit or not, whether the long-term interest of shareholders will be protected or not. So that's what happened in the Unilever Kraft Heinz bid. And again, it's a case study in Harvard itself to say how a cultural misfit can be a reason to reject a bid, right? And again, this is not something which is written in the books of law. This is not something which is written anywhere in any of the regulations. So the point I'm just trying to make is that while the takeover code provides a lot about the procedural aspects, when the triggers will happen, what you are supposed to do, a lot goes behind while taking these decisions, right? These are big decisions which can impact the longevity, sustainability of an organization, and a lot goes behind on that. So I would just possibly end by saying that people who are dealing with this subject try to keep the governance norms on a very, very high ground. see what is good from a shareholder point of view, see whether you are transparent while giving information to the shareholder or not, and see whether the shareholders have enough information to make a very informed decision or not. So that's what I would say, Dipti. I will stop here, not take much time. Thank you.
Thanks. It was really useful information and sharing experience to look at the what is takeover code intents. You know, what is written behind the word, you can very well visualize. Thanks a lot, Amit, for sharing the experience. Mr. Bala, just 2 minutes for you to talk on the topic.
Good morning to all of you. We heard a lot on the takeover code from Dipti and Amit. I have nothing to talk on the topic as such. But one thing I would like to share with the audience here. The takeover code is not the one which is going to happen day to day when you are working in a company. In some companies, it may take, in some companies, it may not take at all, you may not see in your lifetime also. Those people who are worked with the takeover code, those people in the company where takeover is likely to take place, etc. This topic is very interesting. There are a lot of nitty-gritties. There are a lot of things which you have to experience other than theory. That is there. I was lucky enough to work in a company where I had seen the open offer given by a disinvestment process by one of the major shareholders, which was taken to the open offer to the people. And between 2001 to 2007, I have seen 3 takeovers. I was associated with that. And you all will be knowing, at least some of the people who are in between 2000 and odd, they will be knowing. There was a popular case with the SAT, BP PLC, BP Abaco PLC versus Posico PLC at UK. That triggered the case between the Sebi and the company. And the matter went to Sebi, Sebi again went to SAT. And ultimately, as Amit said, shareholders' interest. When the open offer is to be made, again, the overseas open offer made somewhere in the month of March 2001. But whereas they applied for the exemption, etc., it is not applicable in India, it is overseas, etc., and other thing and all, but ultimately that did not work. It has been told to no, sorry, whatever the companies in India is being taken over, open offer is to be given. That is a judgment which has come. Sebi has said that actually, and they appealed against that. In the process, what has happened is they made an open offer, but they made it almost after 5 to 6 months later. Then again, the matter came up. What has happened is, no, sorry, the shareholders' interest is the must. It should be actually the date on which original offer was made in overseas countries, not this particular case. You will recall, whenever we are ending the year end, the market price is always high. When we come to the first quarter, the market price is always low. So this company, the open offer was made somewhere in the March in overseas, and here the open offer made somewhere in July or August. Obviously, there was a quite considerable price difference. SAT ultimately ordered that not only the price difference is to be paid to the shareholders who are actually offered for the share, but they have to also pay 15% interest from that date till the open offer has been made. Till such time they surrender. That is a judgment which has actually come. It is a very interesting judgment. It was quite some time. It was taken as a case study in various, even our own institute, etc. And all this thing. I used to be part of some of the program. And the Sebi people will say, Bala, we know you cannot participate in the discussion. You are interested party. That used to be the case. So people who are interested, they can go through the judgment. It is a very eye-opener, giving so many nitty-gritties, etc. But the only thing is, we were working with the 1997 code. But thereafter, the code has been amended in somewhere in 2009 and 2011. There are a lot of new definitions. As he rightly said, the independent director report to the shareholders. Many sweeping changes has been brought by the regulators on that. What I look 1997 code and 2011 code, there's a hell of a lot of differences working towards taking care of the interest, protecting the shareholders, giving the better option to the thing, and also giving to the board of directors to make a suggestion, study the thing, do the due diligence, their homework, and the independent director responsibility has been increased to the greater extent. All the things are other which, as Amit puts it, we cannot learn the theory or paper, etc. and other things. As we experience, we will learn, or otherwise we need not experience ourselves, but we can from others' experience. So today's topic is definitely, since Amit has handled not only nationally but also internationally, definitely his experience will be great benefit to all of us. If sometime or other we have an opportunity to to associate with the takeover, etc., it will be a great help to us. With these words, I will ask Jasveen to proceed with the presentation. Thank you.
Thank you so much, sir. I'll just share my screen for the presentation.
Yeah.
So the Sebi substantial acquisition of shares and takeover regulations, popularly known as the Takeover Code, is what we're going to discuss on. So is takeover a new concept? Not at all, in fact. Even in the ancient times, to expand territories, we know that kings and kingdoms used to fight with each other to expand their kingdom and territories. In the corporate setup, takeover is nothing but a battle between the corporates. The first wave of takeover came in the 19th century in countries like US, UK, etc., but it needed time till the 20th century to penetrate in the Indian context. But still the concept of hostile takeover, where without the will of the target company itself, the acquirers go ahead and make an offer for the shares of the company. That concept was not popular until one Mr. Swaraj Paul, who was an NRI, made a hostile bid to acquire Escorts Limited. This was a wake-up call for the regulators, and there was felt a need to develop a sophisticated guideline to govern takeovers in India. Prior to 1992, the listing agreement contained clauses for substantial acquisition and takeover. 1992 was a landmark year as far as securities regulation is concerned due to the enactment of the Sebi Act. Pursuant to the powers under Sebi Act, Sebi went ahead and issued the first regulation on takeover in 1994, which was Sebi SAST regulation 1994. This was majorly an adaptation of the clauses of the listing agreement itself. But due to the changes in the corporate structure and the corporate environment, there was felt a need to revamp the entire regulations. For the purpose of which, in the year 1995, the Bhagwati Committee was constituted. On the basis of the recommendation of the Bhagwati Committee, the 1997 regulations were enacted. This 1997 regulations were amended 23 times until in 2009, the Achyutan committee was established to completely review and revamp the takeover regulations. On the basis of the recommendations of the Achyutan committee, the 2011 regulations as they stand today were notified. So let's see what power from which sections of Sebi Act does Sebi derive the power to issue the SAST regulations. So one is section 11, very important section of the Sebi Act, where it says that the board can take measures for regulating substantial acquisition of shares and takeover of companies. As an extension to section 11 is section 12A, which says that no person can directly or indirectly acquire control over any company which is a listed company unless it follows the regulations relating to takeover and substantial acquisition. This read with section 30, which gives power to Sebi to issue regulations, contains the entire ambit from which Sebi has derived power to issue these regulations. Like Amit sir had pointed out, the objectives of the takeover code. Why exactly has this code been set up, and what is the vision of the regulator for the enactment of this code? This was pointed out in the Takeover Regulations Advisory Committee headed by Mr. Achyutan in the year July 2010. This report states that the takeover code has the major objective of one, ensuring a legal, transparent procedure for the purpose of takeover where a continuous disclosure is given at every level. Second is to balance the interest of all the stakeholders who are involved. Third is to provide an exit opportunity to the shareholders. Again, like Amit sir said in his introductory remark, if there is a change and shift in the management of the company, the shareholders should be given a right to exit from the company at such time if their vision does not match with the new management. Then ensuring a transparent legal framework to acquirers while carrying out the open offer process and acquisition. ensuring fair and effective competition among the acquirers themselves to ensure that the best price is given to the shareholders for their exit, ensuring safeguards so that only the acquirers who are actually capable of fulfilling their obligation can make the open offer. And the last and the most important that has been safeguarded by SEBI number of times is the affairs of the target company shall always be carried out in ordinary course during the open offer period. So the management cannot tamper with the operations. Applicability of the regulations. When will these regulations come into picture? The regulations will apply to direct or indirect acquisition of three things: shares, voting rights, or control over a target company. What is a target company from the SAST perspective? Any company whose shares are listed on a stock exchange in India is regarded as a target company. So whenever there is acquisition of three things, shares, voting rights, or control of these companies, SAST comes into play. The broad structure of the takeover regulations, it has 6 chapters in all, comprising of 35 regulations divided into different subheads. We'll discuss this as we go ahead. Important definitions that need to be considered before we go into the entire procedure and triggers. First is acquisition. Since the main applicability provision says that this applies to acquisition, so we have to understand what exactly is acquisition as defined in the takeover code. Acquisition means directly or indirectly acquiring or agreeing to acquire. Again, those few triggers: shares, voting rights, or control over the target company. So let's say today I enter into an agreement to purchase the shares of, say, some X Limited listed company, and the agreement says that I will acquire those shares 30 days hence from the date of execution of the agreement. My acquisition as per this definition triggers on the date of execution of the agreement itself. So from this perspective, if an acquirer, say Alpha Limited, acquires shares, voting rights, or control of the target company, say Theta Limited, then this entire setup is known as an acquisition. As an extension to the definition of acquisition is the definition of acquirer. Any person who directly or indirectly acquires or agrees to acquire the shares, voting rights, or control over a target company is referred to as an acquirer. So in this case, Alpha Limited, who acquires shares, voting rights, and control, will be referred to as the acquirer. And he can do so, the acquirer can do so either by himself or through or with persons acting in concert with him. Persons acting in concert is a term which has been extensively defined in the regulations to mean a person who, with a common objective or purpose. And what will be this common objective? It will be of acquisition of shares or voting rights or control over the target company, pursuant to an agreement or understanding, cooperates with the acquirer for acquisition of the shares, voting rights, or control. So 2 important elements of this definition are: 1, there should be a common objective or purpose, and second, the person acting in concert should cooperate with the acquirer for the acquisition. As an extension to this definition, certain people, pursuant to their relationship, have been deemed to be person acting in concert unless the contrary is established. So the burden of proof will be the person who is alleged to be the deemed to be the person acting in concert. So who shall be these deemed person acting in concert? It shall be the company, its holding company, subsidiary company, and any company under the same management. The company and its directors and management, directors of the company, which is a subsidiary company or a holding company of that company, promoter and promoter group, immediate relatives has also been defined. Thereafter, in case of mutual fund, collective investment schemes, venture capital funds, and alternative investment funds. In case of these 4 funds, the sponsors, trustee, and management company of these funds. Thereafter, the merchant banker and its client, portfolio manager and its client, the bankers, stockbrokers of the acquirer. All of these are persons acting in concert, deemed to be persons acting in concert. In the case of, there was a very famous Supreme Court judgment in the case of Daiichi Sankyo, wherein the Supreme Court said that these provisions of deemed persons acting in concert should actually be read with the first part of the definition, which means to prove or to disprove that a person is deemed a person acting in concert, you have to ensure that there is common objective as well as cooperation for acquisition. Only if these two are met, only then you can say that the person is actually deemed to be a PSC. Who is an immediate relative? Immediate relative is the spouse of the person and parent, brother, sister, and child of the person himself and the spouse. One of the most important definitions from the perspective of this regulation is the definition of control, because takeover applies not only to acquisition of shares and voting rights, which are quantifiable, but also to control, which is majorly a question of fact. So these regulations have given a very wide definition of the word control. It says control includes right to appoint majority directors or control the management or control the policy decisions in the target company, exercisable by a person or persons or a group of people, including by virtue of. So how would they derive this right or control? By way of shareholding, management rights, shareholders agreement, voting agreement, or in any other manner. So there is, say, suppose a debenture agreement as well, but pursuant to that agreement, if I derive the right or control over the company, then that is also included as control. In one of the very famous case laws of Shubham Ventures India Private Limited, SAT in his judgment had defined the ambit of the word control, since it can include a lot of things, but it says that affirmative vote shall not be constituted as control. I'll just brief in a very short manner the facts of the case. So in this case, an agreement was entered into by the company and one of its investors, wherein the agreement stated that the investor shall have the right to block certain resolutions. So even if the threshold under Companies Act or the regulations are met, if this investor says no to the resolution, that resolution could not be passed by the company. So Sebi decided that this is indirect control by the investor on the target company. However, SAT overruled that decision and said that control is only a proactive right and not a reactive right. If the power by an acquirer, if the person has the power to command the target company, then he is said to be in control of the company. And the real test that lies is to ensure that the acquirer is in the driving seat. So all the decisions, etc., in the company that are important for the target company to say so are taken by this person. Only then it can be said that this person is in control of the target company. Any protective rights in the investors agreement, like right to appoint nominee directors, etc., is not actually control. Sebi has also pointed out the same in one of its discussion paper. What are shares from the perspective of these regulations? Shares would mean a share in the equity share capital of the company carrying voting rights, and would include any security by whatever name, type, etc. it is called, which entitles the holder to voting rights in the company, and would include depository receipts, ADR, GDRs that carry voting rights. So if we can see an overall picture, what is important for the definition of shares is it should carry voting rights. Last definition that is important is the definition of offer period. So offer period is the period between date of entering into an agreement or entering into any transaction that obligates the person to make a public announcement, or the actual date when the public announcement is made, whichever is earlier, till the date on which the payment of consideration is made and the offer is completed, or the date of withdrawal of offer, as the case may be. Now we come to the most important part of the entire regulations, which is open offer trigger. what are the circumstances under which I have to make the open offer? Open offer in a brief sense means I have to give a right to the shareholders of the company to tender their shares. So when do I hit this trigger?
Jasveen, could you please go to the definition of shares?
Yes, sir.
Yeah, the second column
Yes.
includes any security which entitles the holder to exercise voting rights.
Yes.
Would this cover preference shares where dividend has not been paid?
Yes, it would. It would. It would.
So one has to be very, very careful if your dividend is not being paid on preference shares.
Yes, I'll give you an
Now, are you covering this afterwards?
Yes.
Okay,
Yes.
Then
There's
what?
an exemption granted by Sebi for that.
Achha, okay.
But in the larger sense, it is covered as shares in the definition of shares.
All right. Thank you.
No problem. Yes. So the three important circumstances under which the open offer trigger would be hit is direct acquisition of shares or voting rights, acquisition of control, and the third is indirect acquisition of shares, voting rights, or control over the target company. Regulation 3 covers direct acquisition of shares or voting rights, in which subregulation 1 states that no person, no acquirer shall acquire shares or voting rights in a target company which entitles him, so the total holding entitle him to 25% or more of the voting right in the target company, unless he makes a public announcement of an open offer. So let me give you an example for this. Let's suppose I hold 10% of voting shares in a company, in a listed company, and I go ahead and enter into an agreement to acquire another 15%. So I cannot do so unless I make a public offer of the a public announcement for the open offer. The second threshold is under regulation 3.2, which states that a person who already holds 25% or more of the voting right shall not acquire more than 5% of voting rights in any financial year. If he has to acquire more than 5%, he has to first make a public announcement for an open offer, and only then he can do so. Certain conditions for this acquisition norm. Now, if the acquisition is pursuant to, say, a fresh issue, then the difference in the pre-allotment and post-allotment voting percentage should be taken into account. And the second is only gross acquisitions shall be considered. So when we say that you cannot acquire more than 5% voting right, what we mean by this is a gross acquisition. That means you should not net off the disposal effect. I'll give you an illustration for this. This is one Mr. A is holding in a financial year. Okay, so let's suppose in April, on 1st April, he holds 27% voting right in a listed company. In the month of June, he goes ahead and acquires 3% of voting right in this company, making his shareholding to 30%. In the month of July, he further acquires 1%, rendering his total voting rights to 31%. Then in September, he sells 4% of the shares, leading to a shareholding of 27%. In the month of March, that is prior to the end of the financial year, he acquires another 3%. Now, if we see from 1st April to 31st March, the net increase in his shareholding is only of 3%. That is 30% minus 27%. But for the purpose of this regulation, we have to take in account gross acquisition, which is 3% plus 1% plus 3% in a financial year. Since this is 7%, more than 5%, he hits the trigger of open offer under regulation 3.2. In case of interstate transfer between an acquirer and person acting in concert, if due to any transaction, an individual shareholder of the acquirer or PAC attracts the obligation to make an open offer, he has to make the open offer individually, irrespective of the change in the aggregate shareholding. So let's say Mr. A along with B and C. B and C are persons acting in concert. Mr. A is the acquirer. A holds 10%. B holds 10% of the voting right, and C holds 5%. So the aggregate shareholding is 25% of Mr. A and group. Now, Mr. A and B go ahead and sell their shares to Mr. C. A now holds 0%, B holds 0%, and C holds 25% of the voting right. In this case, the aggregate shareholding still remains 25% of A and group, but since C's shareholding is 25%, he hits the open offer limit under 3(1), and C, in his individual capacity, has to make an open offer. For the purpose of Innovators Growth Platform, any company listed on IGB, the limit of 25% should be read as 49%. This is a relaxation given to these kind of companies. So let me give you a summary of Regulation 3. Any shareholding within 25%, no need to make any open offer. The moment you hit the initial threshold of 25% voting right in the listed company, you have to give your first open offer under Regulation 3(1). Between 25% to 75%. Why 75%? That is the maximum permissible non-public shareholding as per the Securities Contract Regulation rules. So between 25% to 75%, you can acquire any amount of shares or voting rights up to 5% in any financial year. The moment you have to acquire more than 5% in a particular financial year, you have to make an open offer for the same.
Jasveen,
Yes.
there is a questions in the chat box, and as regards Mr. Samir for structured digital database, we'll take it later. But the one question he has asked, appointment of a shadow director, whether fall under the definition of control or not.
Which director, ma'am? Could you repeat that?
Shadow director.
Not really, it does not. Also, the main thing is what you have to see for the purpose of control, and Amit and Balakrishnan, you can correct me if I go wrong, is you have to have control over majority of the decisions in the board. So if you appoint a director who takes all the decisions in the board, only then that would amount to control. Shadow director, I'm not sure.
Amit, your view, please.
Yeah, that's true. I think what Jasveen is saying is right. And control in a way is say that, instead of kind of acquiring the voting rights, which for whatever reason, if you don't want today, you try to get a backdoor entry and try to kind of have a point of view on the affairs of the company. So if you are able to exercise a point of view on the affairs of the company, able to drive board decision making, that's where in a practical sense, control comes into picture.
Okay, thanks.
I would also say on this slide, Jasveen, I think, I'm just kind of practically speaking, while within 25% no public offer is required. The fact is, if somebody is doing a creeping acquisition and trying to kind of build equity from, you say, 1% to 2% to 5%, the disclosure norms are there. And I think you are going to cover that, right? And those disclosure norms are also, by the way, have come in to tell shareholders that there is somebody who is building that equity base over a period of time to kind of get into, because if somebody is kind of consistently kind of increasing the shareholding over a period of time, it is one giving an indication to the corporation that somebody is interested in trying to build it. It is also an indication to the shareholder that the open offer may come up in near future. So somebody has reached from 1 to 15%, you can very well expect that. Right. What is the intention of that? So I think practically speaking, and again, from a company secretary's point of view, those are the things you need to kind of keep in mind while tracking your week to week change of shareholding, that who is the one where the movement of shares are happening. As Jasveen said, who are the people acting in concert, and are people acting in concert are kind of building shareholding over a period of time, which will take them to this limit. So I think even what happens before 25% is equally relevant from a corporate point of view.
I think something you have answered. Another question from Mr. Srinivas Rao, whether promoters tendering shares in the proposed buyback of the company triggers any takeover regulations. I'll repeat, whether promoters tendering shares in the proposed buyback of the company triggers any takeover regulations.
promoters tendering shares in the buyback process will reduce the shareholding, right? So my mind, it will not kind of trigger any takeover regulations.
So possibly, I think the meaning of the question is if the proportionate shareholding changes, voting rights change due to that, since the total number of shares decreases.
So somebody else's comes into the picture.
Yes, yes. So in that case, it will be triggered, but SEBI has given exemption for it. We'll cover that in the subsequent slides.
Yep.
I agree with her. There is an exemption given specifically for the buyback and by SEBI regulations.
Yes.
Yeah, so I think Mr. Assis has suggested, can we take the question later on once the presentation is over, please? So Jasveen, if anything coming later on, then you stop there, that the matter is covered later, we'll take it later.
Okay.
Let's go on the presentation.
Yes. Okay. Regulation 4, quite a straightforward regulation which says, irrespective of the shareholding or voting right, any acquirer who acquires control over a target company shall make a public announcement for an open offer before acquiring this control. Regulation 5 deals with an indirect acquisition. So let's suppose an acquirer smartly does not acquire the company directly. What he does is he acquires a company which gives him the right and control over a third company, which is a listed company. Now, this is also being covered under these regulations as an indirect acquisition. So let's see what it reads. It says regulation for the purpose of regulation 3 and 4. So it's just an extension to 3 and 4. It says an acquisition of shares, voting rights or control over a company or other entity that will enable the acquirer to exercise or direct the exercise of such percentage of voting rights or control over the main ultimate target company that would otherwise attract the obligation to make an open offer will be regarded as indirect acquisition. Let's understand this better by way of an illustration. Let's say Mr. A and Group is the acquirer. They acquire 60% of voting right in B Private Limited. Now, this won't attract the takeover code since B is a private limited company. Okay, but this B Private Limited holds 35% of shares in one X Limited, which is a listed company. Now, due to the acquisition of 60% by A and Group in B Private Limited, they get the right to exercise this 35% vote in X Limited. This is nothing but indirect acquisition of 35% of voting right by Mr. A and Group in X Limited. This is one of the most classic examples of an indirect acquisition. The second is, now let's suppose Mr. A and Group acquires only 25% of the shareholding. So he's not a majority shareholder in B Private Limited. But while making this investment of 25%, he says that there's a clause in the AOA that says that the voting rights in X Limited will only be exercised as per the will of Mr. A and Group. Now, this is directing the exercise of 35% of voting rights in the X Limited, which is a listed company. So this will also lead to an indirect acquisition and attract the open offer norms. Deemed direct acquisition, certain indirect acquisitions, if they meet with certain norms as stated here, they will be deemed to be direct acquisitions for the purpose of this regulation. What changes for these deemed direct acquisitions versus indirect acquisition is the pricing and timing to make the open offer. So if the proportionate NAV of the target company, so in our example, company X, as a percentage of the consolidated NAV of B, of the entity being acquired, exceeds 80%. So to put it simply, NAV of X divided by NAV of B into 100 exceeds 80%, then this acquisition, though indirect in nature, it shall be deemed to be a direct acquisition for the purpose of this regulation. Second, a similar norm, proportionate sales turnover of the target company as a percentage of the consolidated sales turnover of the entity being acquired. So sales turnover of X divided by sales turnover of B into 100 exceeds 80%. This is a deemed direct acquisition. Last norm is a proportionate market capitalization of the target company as a percentage of the enterprise value of the entity being acquired exceeds 80%. If they meet any of these three conditions, it's an or. So any one of these hits, it shall be treated as a deemed direct acquisition. Okay. So in regulation 345, what we dealt is a mandatory requirement. So if you hit this trigger, you have to mandatorily make an open offer, unless otherwise you will contravene the law. But there is also an option given to acquirers to give a voluntary open offer. That is, when they do not hit any of the triggers, they can voluntarily come ahead and give an open offer to the shareholders. Only if they hold 25% of the voting right in the company, and they should not have acquired any shares of the target company during 52 weeks preceding the date of the public announcement without making an open offer. And the last is, after the voluntary open offer is completed, for 6 months ahead of the completion of the open offer, they cannot make any other acquisition of the shares or voting rights in a target company unless they make a subsequent voluntary offer. Willful defaulters and fugitive economic offenders have been prohibited from making an open offer. Willful defaulter can only make a competing offer in case of a open offer process. In a very brief form, I've tried to cover the open offer process. So this is the entire process that has to be followed. First, it begins with appointment of a merchant banker. Merchant banker shall be the manager to the open offer. This merchant banker shall be responsible to issue any public announcement, any filings that are to be done with Sebi. This merchant banker, who is the manager, would be responsible to do the same. Then the public announcement of the open offer has to be made. The timing of the public announcement depends on the transaction on the basis of which you have derived the 25% when you hit the trigger. So it will depend on that transaction. Public announcement is required to be given to the target company at its registered office and every stock exchange where the target company is listed. So this is when the knowledge comes to the stock exchanges for the first time of the acquisition. Then you have to go ahead and open an escrow account 2 days prior to the issue of detailed public statement. Detailed public statement is the first time when the acquisition comes to the knowledge of public at large as well as the shareholders of the company, because this has to be published in newspapers now. The detailed public statement, which has to be made within 5 working days from the date of the public announcement. Within 5 days of publication of the detailed public statement, filing of the draft letter of offer has to be done with Sebi. Sebi is obligated to give its comments within 15 working days. If the Sebi comments are not received during this timeline, then in that case, it shall be deemed that Sebi has given its approval for the letter of offer. Any changes that are suggested by Sebi have to be incorporated, and the final letter of offer shall be dispatched to every shareholder of the target company within 7 working days from the date of receipt of Sebi comments. If the acquirer wishes to make any upward revision in the offer price, he can do so only 1 working day prior to the beginning of the tendering period. 1 day prior again, the advertisement containing the entire activity schedule in the open offer has to be given. Now the tendering period commences, which has to commence within 12 working days from the date of receipt of the Sebi comments. What is the tendering period? It is the period during which the shareholders will actually give their shares. So they'll exercise their right to take an exit from the company. The tendering period will last for 10 working days. This is the fixed period. There cannot be any increase or decrease in this tendering period. Once the tendering period ends, within 10 days from the end of the tendering period, the acquirer is obligated to make payment of consideration as per the letter of offer to all the shareholders who have tendered their shares. And within 5 working days from the end of the open offer period, a final advertisement has to be issued by the acquirer stating the number of shares that he has received, the date on which the payments have been made to the shareholders, etc. So the summary of the entire offer would be given in this advertisement. Then a final report has to be submitted by with Sebi, who will submit this? The manager to the open offer. And this is to be done within 15 working days from the end of the tendering period.
Amit, you can surely interrupt and give your comment as and when you want, please.
So sure, I think the only reflection on this is that while this public statement seems to be very simple, it's a quite complex piece of information, right? And if it is a voluntary takeover process where still there could be some amount of coordination between the target and the acquirer, even then there is a lot of information that has to be taken by the target company to the acquirer, put in the public statement. And a lot of that information actually is a historical information. So one of the learning for me clearly was the importance of knowledge management and the importance of historical data, because there's a lot of historical data, by the way, that goes into this document. If there is a mismatch between the data you have put in and the data that Sebi has in their records, then the whole thing goes for a complete toss. So I think very, very important to have a coordination. If you are advising an acquirer, then please see what all is required and what is your dependency from the target company. If you are at the target company side, then also see that information may be asked from you, whether it is a case of any kind of acquisition. So I think drafting a good public statement and with all the information that Sebi needs is an important one. There's a lot of coordination again between depositories, Sebi, all other stakeholder merchant bankers, which has to be work in a tandem fashion and work in a time-bound measure to meet the timelines that Jasveen has just kind of put in here. So she has explained it in a very nice way, the things, how it works and how the law envisages. But as I said, in practical words, there is a chaos that happens in this, and there's a lot of coordination that is required. So that's what I would just say, Dipti. Thank you.
So in that any particular, tense period you must have gone through and the kind of experience you have that you would like to share, that how you handle it kind of.
Yeah, I think one of the issue was, I think one of the information which they asked for is information about non-compliances and issue or any kind of a notices of non-compliances by that the target company had in the past with respect to Sebi regulations, and it goes back to a very historical information, right? Asked for, and the other thing I think which asked that is the build-up of the shareholding over a period of time. That was the other information which was there, saying how the shareholding has been built up over a period of time, and that goes back to like the the first time the IPOs and then offers and all of that. So somebody who is new to the company, who has to kind of build this kind of information, unless this information is available somewhere readily, becomes a stress. So I think those two data points I clearly remember was a challenge to go and pull out that where do we get this information. Shareholding was still a bit easier. I would not say very easier to build from annual report to annual report, saying how changes have happened because the information is available, but the notices and any kind of a breach that would have happened that you would have compounded or otherwise becomes really a challenge. And typically in a life of a company, you would say, okay, this issue was there, it was done and dusted, over. So you would not have all the details available if it is a 10-15 years old information, right? So but when it comes to providing information, then all of this is required. So I think yeah, those two I clearly remember were a little bit of challenge.
So it can be said that a company secretary department and CS has to take care of all the notices and all its compliances and the record for that.
Absolutely, you are the only one the whole company and the whole world is looking at that point in time, saying you give the information. Now whether you have that information or not is not something, but you are the only one who can provide that information. So I started by saying that the knowledge management and documentation management becomes very, very important at scenarios like this. In a normal working, we at times don't understand that this is the information which may be needed at one point in time. But the fact remains, if you are a secretarial person and you are handling a company secretary department, each and every event in the life of the company may become relevant at some point in time, to put it very, very broadly, and particularly when it comes, because the regulator expects you to kind of have that kind of historical information.
It goes without saying to the company secretaries, either in the employment and other thing, to have an excellent record maintenance is an absolute necessary.
Yeah.
where I was working, the company which is old more than about 50, 60 years, although law says 8 years record, etc., and all the thing, what we have done is we have done all the permanent record, classified, indexed, etc. And here we have actually given it to a third party where he stores it as per our index, etc., and other things are done, who's again a knowledgeable person. So at a phone call, the record will be made available not later than 24 hours, what exactly we need. Because 8 years, immediately we will locate from here, it is over there, we have a system, what you call some sort of the compact record keeping management we kept actually. But inadequacy of the space, etc., this is what you have done in another location within the city only. So you have excellent people who are managing this, etc., and other thing and all, that is what. So what is required is, you know, as Amit puts it, oh, matter is over, close the matter, nothing. It is not the case. It has to be preserved right from the beginning till the end. What is started, what is the issue, what are the things, it should be available. Any point of time, anytime regulator will come out, we do not know. Because this takeover, etc., is once in a lifetime of a company. It may not happen every day. Suddenly, if that happens, you will be searching the records.
Right.
There is a popular saying, you know, don't they rage jaoge. So that should not be the case. That should be avoided. Yeah.
Okay. Yeah, thanks. Yeah, Jasveen.
What will be the offer size under this open offer in case of a mandatory open offer under regulation 3 and 4 when you hit the trigger? For that purpose, it is minimum 26% of the total shares of the target company. Now, this is a futuristic approach as on 10th working day from the closure of the tendering period. So actually, the acquirer has to do a reverse calculation, and on the basis of that, he has to offer 26% at least in the open offer. In case of voluntary open offer, the limit is minimum 10% and up to maximum 75%. To whom this open offer is required to be made? All the shareholders of the target company except the acquirer, person acting in consort, and the deemed PSCs. Mode of payment: how and in which form will the consideration in an open offer be paid to the shareholders? It can be in the form of cash, listed equity shares of the acquirers and PSCs, so a swap kind of an arrangement. Third is listed secured debt instruments issued by the acquirer or PSCs, which should not be below investment grade. And last is convertible debt securities, which entitle the holder to the listed equity shares of the acquirer or the person acting in consort, or a combination of these four modes. Provision related to escrow. So apart from the payment being made, on the basis of the consideration that is payable in the entire open offer, the acquirer is required to maintain or deposit certain amount into the escrow account, which shall be in control of the manager to the escrow, manager to the open offer. The purpose of this escrow is to ensure a safety net that in case the acquirer fails in his obligations during the open offer, this amount in escrow will be forfeited. So amount to be maintained in escrow is on the first 500 crores of consideration. 25% of the consideration shall be kept in the escrow, and on the balance considerations, 10% of the balance amount. So let's suppose if the total consideration is 700 crores, I have to calculate 500 crores into 25%, and on the balance 200 crores, I have to keep aside 10% of that amount in the escrow. In case of indirect acquisition, 100% of the consideration shall be deposited in escrow account. Conditional offer. An option is given to the acquirer to make a conditional offer. What is the condition in such an offer? The condition is with respect to minimum level of acceptance. So let's suppose the acquirer makes an offer for 26% of the equity shares of the company, but he puts a condition in that offer that I shall acquire at least 10% to make the offer successful. If the acquirer fails to acquire this 10%, then he has the right to withdraw from the offer and say that I'm not going to acquire any shares of the target company. Restrictions in case of conditional offer: acquirer and person acting in consort cannot acquire any shares of the target company during the offer period. And second, the requirement for escrow to be maintained in cash is higher of 100% of the minimum level of acceptance or 50% of the total consideration. So this has to be maintained in cash in the escrow account by the acquirer for conditional offer. Competing offer, regulation 20. This means that when a person other than the acquirer, the original acquirers, competes to obtain or get the shares of the target company. Now, this person can also be the promoters of the target company themselves. So in case of a scenario of a hostile takeover, where the board of directors of the target company are actually blocking such a acquisition, they can themselves make the competing offer as well. This competing offer shall be made within 15 working days from the date of issue of the detailed public statement. The quantum amount of in a competing offer should be minimum current holding of the acquirer plus the offer size in the open offer, plus if there is any other underlying agreement pursuant to which the original acquirer will acquire further shares, then that should also be taken into account. Revision in the terms. So to compete with this acquirer, the original acquirer can revise the terms of the open offer. Terms in maybe it can be in terms of offer size, offer price, etc. But they should be such that they are more favorable for the shareholders. So the shareholders' rights should not be affected by it. And an upward revision of the price can be made up to 1 working day prior to the commencement of tendering period. In certain cases, Sebi has allowed the withdrawal of open offer. In case where a statutory approval is required for the open offer. So let's suppose that the commission, permission of the or the approval of the Competition Commission of India is required for a proposed acquisition or open offer, and this approval is finally refused by the regulator. Then in that case, the acquirer has the right to withdraw the open offer, subject to the requirement that they have stated in the DPS and the letter of offer that this approval from such and such a regulator was required. Now, this can be applicable in case of any regulator, so Competition Commission, or in case of telecom sector, TRAI, or if RBI sanction was required, but that was refused. Next is where the acquirer is an individual person and he meets natural death. In that case, Sebi definitely will allow withdrawal of the open offer. If there is a condition in the agreement for acquisition attached to the open offer and that condition is not met due to reasons that were outside the control of the acquirer. So let's suppose, like we said in the conditional open offer, where the minimum level of acceptance is not met. So in this case, they can withdraw the offer. Or for any other reason, as Sebi may deem fit, but Sebi has to pass reasoned order for allowing such withdrawal. If a public announcement is made pursuant to a preferential issue when we acquire the shares and the preference issue shares, no right of withdrawal shall be granted to such an acquirer. And the announcement, public announcement for withdrawal shall be made within 2 working days from the circumstance of the withdrawal. It shall be made in newspapers, shall be filed with Sebi, stock exchanges, and the target company as well. Exemptions from open offer. So the many questions that were coming up in relation to whether buyback would attract it or whether preference shares would hit the requirement. Sebi has granted 2 categories of exemptions. One is automatic exemptions, that by purpose of the transaction itself, an automatic exemption is given to the acquirer who hits the trigger. Second is on the discretion of Sebi, power has been granted to Sebi to grant an exemption from the requirement of making an open offer. Quite recently, the government of India, the central government, was given an exemption from the open offer when they acquired 33% of shares of Vodafone India Limited, pursuant to the conversion of the ADR dues of Vodafone. Okay, so now regulation 10, which states automatic exemptions. What are the circumstances for this? In case of interstate transfer among immediate relatives, promoters who have been named as promoters in the disclosures for at least minimum 3 years period, third is when the company, its holding company or its subsidiary company, if there is any interstate transfer among them, then that would be exempt. For persons acting in concert, any interstate transfer between the acquirer and the person acting in concert who has been the PAC for at least 3 preceding financial years. And last is whether shareholder who is a person acting in concert for the company, if he acquires any shares in case of an interstate transfer, that is exempt from the requirements to make an open offer. Second is in circumstances of ordinary course of business. So let's suppose in this case, if the underwriter pursuant to an underwriting agreement acquires more than 25% shares of the company, then he is exempt from making the open offer. Next is the stockbroker. If during the ordinary course of his business, such stockbroker acquires shares, that shall be exempt. Merchant banker in course of his activity, stabilizing agent as specified under ICDR regulations, so to stabilize the price of the shares of the company, if he acquires certain shares beyond the threshold, that shall not attract the open offer requirement. Market maker and scheduled commercial bank who exercise lien on the shares. So if they acquire shares due to that, that will be exempt. Acquisitions pursuant to a scheme. So if a scheme is sanctioned under SICA, where the sanction of BIFR has been received, that is exempt. In case of merger, where the target company is the transferor, that shall be exempt, subject to such merger should require a court or tribunal sanction, whether in Indian jurisdiction or foreign jurisdiction. In cases of merger where the target is not directly involved either as a transferor or the transferee, in that case, if the component of cash involved is less than 25% of the consideration, plus where the shareholders get at least 33% of the voting rights in the merged entity, in these circumstances, this merger would be exempt. Resolution plan under IBC would be exempt. So any person who acquires shares pursuant to a resolution plan will be exempt from the requirement to make an open offer. Acquisitions pursuant to SARFAESI Act, pursuant to delisting regulations, if all the requirements of the delisting regulation have been met, pursuant to transmission, succession or inheritance of any shares. Here is where it comes in. So where it says that if preference shareholders are acquiring voting rights in the target company due to non-payment of dividend for 2 years, that is exempt under the exempt from the requirement to make an open offer.
Silence boy, your question is being discussed.
Okay. In case of conversion of debt to equity, pursuant to a debt restructuring scheme as per RBI guidelines, in case of increase in the voting right due to forfeiture of certain shares. So if certain shares of the company have been forfeited, that make my proportionate voting right beyond 25%, this is exempt from the requirement of open offer because this was not in my control. Next is increase in the voting right due to conversion of shares with superior voting rights into ordinary shares. In case of buyback, the question that was discussed, if there is increase in the voting right due to a buyback, the shareholder is given a time of 90 days from the closure of buyback to reduce his shareholding beyond the trigger limits. This is in case of 3-1. So 3-1 when 25% requirement has to be met. Now, specific exemptions under regulation 3.2, to remind you, 3.2 is 20, if I hold 25% and in a financial year I acquire more than 5%. So in that case, if that is pursuant to rights issue, if I am taking shares, right shares up to my rights entitlement, that is exempt. Even if I subscribe to shares that are beyond my rights entitlement in the right issue, then it shall be exempt only if the acquirer has not renounced any of his right shares and the price of the rights issue is not higher than the X rights price of each share. 3.2 exemption for buyback is first condition remains the same, that the shareholder should reduce his shareholding within 90 days. And second is if the shareholder, if the buyback was put to shareholders vote by postal ballot and the shareholder who has acquired the shares voted against the buyback, in that case it will be exempt. And if the shareholder is also the director, then for a resolution of the buyback, I as a director voted against the buyback. Only then my requirement would be, acquisition would be exempt from the open offer. That was the exemptions. So
Jasveen, can you just look at this possibility? And Bala, you also. We have covered rights issue here. Now, in a rights issue, I am say holding 24.9% of the shares prior.
yes.
The rights issue is made, and the rights issue is subscribed only to the extent of 93%. Say, so it is a valid rights issue because it's more than 90%.
Yes.
And the allotment is made. I have subscribed to my rights entitlement. Okay, but because the issue was not fully subscribed, it was only 93% subscribed. My shareholding goes up from 24.9 to something like 25.1 or 25.2. Is this covered in any of this rights issue thing?
No, so because the exemption is in regulation 3.2 for the rights issue.
So then what happens to me? I have done nothing. I have subscribed only to the extent of my rights entitlement. Because others did not subscribe, and still it was between that 90 to 100% subscription, which makes the issue go through. My holding has gone up to 25.1, 25.2, whatever. What happens? Am I to make an open offer? Or do I get into that 90 days thing which you had shown earlier? Where am I?
90 days is only for buyback. So
Yeah,
by law, I would
only
be
for
obligated.
buyback. It's only for
I would
buyback.
be obligated to make it.
Then am I required to make an open offer? Very unfair, no?
Amit, your view?
Sorry, I didn't get
I'll
your...
explain. I think I'll explain again. I'm holding 24.9% in a company.
Yeah.
The rights issue is made. Then the rights issue is made. I fully subscribe to my entitlement. So if everything had gone on hunky-dory fine, I would have remained at 24.9%. But
right.
What happened was that the issue was subscribed only to the extent of 93%.
Okay.
Since it is between 90 and 100, the issue goes through. It sails through.
Yeah.
The directors do not do anything to put in that additional 7%. They close it at 93%. Consequently, my 24.9% holding now becomes a little bit more than 25. It could become 25.1, 25.2. I have crossed the threshold without any active action on my part.
Yeah.
Am I required to make an open offer? Am I covered under this exemption which Jasveen has shown on the rights issue? What happens?
My view is it will be covered under the exemption because the principle is that only that, you know, whether there is action on your part, an active action on your part to acquire control and shareholding beyond the threshold, then only this thing applies. So if I apply the principle on which the takeover code is made, my sense will be it will be covered under this exemption.
Yeah,
But not, huh?
even I believe, because volition or action is crucial.
Yeah.
No, it's not that
Yeah,
your
that is true, correct.
So there's a possibility that though there is not an automatic exemption in this, I can apply to Sebi for exemption under 11.
Silent boy, you have to apply to the Sebi in this case.
Yes.
Sebi will give you 6 months time to reduce your share to the level below the level.
But is it not the responsibility of the share transfer agent to keep a lookout on such things and tell me, hey, look, you are going to exceed 25.1, please sell some shares, or at least write a letter to Sebi or something like that. Or you know, if that 90 days period which you have talked about, Jasveen, you say that is restricted only to certain types of issues, our buyback.
Right.
But
Yeah.
maybe I could be given 90 days to sell and come back to 24.9.
Correct. That is what it will happen. But only thing is you know to make a application.
Yeah.
That is the thing. You know to make an application.
And Sebi has granted such exemption in case of rights issue.
I have come across cases in the Sebi who was granted exemption in the past in some of the companies. But you know to make an application and they will allow you the time period by which you know to reduce your stock level.
Okay. So in any case, I won't be saddled with an open offer.
Yeah, that is right. That will not be. That is definitely not the case, because you are not have any intention to acquire control. You are not initiated any action. It has happened by the process. So you are not responsible for that. So you are not affected by that.
Correct. Okay. Thank you.
Okay. Yeah, just.
Yes. Obligations of target company as well as acquirers during the open offer process. So the obligations of the director of the target company is no representative of the acquirer shall be appointed to the board of the target company during the offer period unless they can be appointed 15 days after the date of the the publication of the DPS, detailed public statement, only if entire consideration or in the open offer is deposited in the escrow account in complete cash form. Second is in case of conditional offer, no directorship in any circumstance can be given to any representative of the acquirer. In case of competing offers, no induction of any director, not only of the acquirer's representative, but no director can be inducted to the board, except in case of death or incapacitation of any director. This vacancy can be filled only subject to the approval of the shareholders. The representative of the acquirer, if he is already on the board of the company prior to the date of the open offer, then they cannot participate or vote in the open offer matters. Obligations on the target company is from the date of public announcement to the ending of the open offer of the offer period. The business of the target company shall be carried out in ordinary course of business. They cannot in any way disrupt the business activities of the company. The target company cannot fix record date for any corporate actions on or after 3 working days prior to the date of commencement of the tendering period. The target company is obligated to furnish a list of shareholders to the acquirer for its acquisition purposes within 2 working days from the acquirer making this request. One of the most important obligations of the target company is they cannot do the following things during the offer period unless a special resolution is passed. What activities are covered under this? They cannot alienate material assets outside ordinary course of business of the target company, cannot affect material borrowings, cannot issue or allot unissued shares that carry voting rights of the target company, cannot affect a buyback or change the capital structure during the offer period. They cannot enter into, amend or terminate material contracts of the target company. And they cannot accelerate contingent vesting rights, say ESOPs, entitlements, etc. They cannot accelerate that during the offer period unless a special resolution is passed by the shareholders to this effect.
I just want to add, Jasveen, that those of you who have kind of handled the normal mergers and acquisition situation, you would know when a company enters into a principle understanding to enter into any kind of a merger. Typically there is an agreement which is entered, right, which will have all these conditions saying during the period till the time the merger is approved or the transactions get completely consummated, the company will not do XYZ things. And the reason for that is simple, that the acquirer has made certain assumptions and valued a company based on its current state of affairs. And if any of these transactions significantly change those assumptions or significantly change that valuation, then the whole premise on which the acquirer is trying to acquire changes. Now, here is a scenario where while there is not a negotiated deal, this is not a deal of merger where you have entered into agreement through law. These kind of a protection has been given to you as an acquirer, that if there is an open offer, then the company will not do XYZ things, because shareholders need to evaluate the offer based on the current situation, based on the current asset position, based on the current borrowing. So if anything is done to change that position, which you have articulated here, significantly changes the assumptions and significantly changes the decision making, and hence some of these provisions find their place in the regulation.
Okay, thank you. Yes, Jasveen.
Thank you, sir. So like was discussed by Bala sir in his opening remarks, the target company is required to constitute a committee of independent directors only, who shall provide a reasoned recommendation on the open offer once they receive the detailed public statement. This recommendation will be given to each shareholder of the company and is required to enable them to understand what would the impact be of the open offer. Again, the target company is to facilitate verification of the shares that are tendered during the open offer process, and they are under the obligation to register every transfer of shares to the acquirer that have been tendered in the open offer. Obligations on the acquirer. Prior to making the public announcement, they shall ensure that the arrangement for payments of consideration have been made and arrangements have been made so that they can effectively implement the acquisition and the open offer. The acquirer is also under the obligation that they cannot alienate the assets of the target company till 2 years after the offer period ends. This prevents asset stripping by the acquirer of the target company. And unless, so now when can they do that? Only if they disclose the intention to alienate any material assets in the detailed public statement and letter of offer. That means a prior intimation was already given to the shareholders for it, or a special resolution is passed subsequently for effecting this alienation. Acquirer shall at all times give true, fair and adequate disclosures in any document that it issues, and they cannot sell the shares of the target company during the offer period. So let's just, from the regulatory part, let's just shift a little to the types of takeovers that are there. There are 3 main types. One is the friendly takeover. That is
Jasveen, since it's type of takeover, we can take the questions, so that will connect to the topic what you have.
After this, I just have disclosure requirements. So anything related to disclosures, we can skip those questions. Other than that, we're almost done.
Yeah. So I will start that first question from Mr. Samir. Structured digital database is an essential and mandatory for every listed company. However, how one has to take care 3 aspects audit trail: timestamping and non-tampering of data, especially in acquisition or expansion. Amit?
We are talking from a this is from a insider trading point of view. Digital database.
I also think that way, Mr.
Yeah.
Samir, can you unmute and just mention what is you intending to ask specifically?
Yes, ma'am. This is from insider point of view, because I have a lot of questions regarding that PIT regulation and regarding disclosure also, because disclosure fall under regulation 30. Then whether they are same or they probably, because STD is now mandatory. They made a mandatory. The Sebi already made a mandatory. So more or less, it does create a kind of a large hue and cry in the CS fraternity. So please at least enlighten us in that kind of manner. Thank you.
So you want to take this topic in this?
No, yeah, it is in a takeover code, because this is totally not, we will take the question on the topic, please, Mr. Samir. Okay, we will take it, we can't take it this on this. Now, appointment of shareholder director, preference dividend, we have covered. Mr. Srinu, whether promoters tendering share, we have already covered. Can we take, okay, how many days it take for completion of entire process approximately?
I already answered this question actually. It depends upon the case-to-case basis. You cannot give a categorical answer. If everything is okay, it can get completed even 6 months. Otherwise, it will run even several years.
And there is a question, is this applicable to allotment of security to an existing shareholder, which leads to their holding exceeding 25% post-allotment? We covered that.
Yeah.
Right, and other places.
Yeah, that is right.
In process, when shall be competing offer be given?
15 days from the date of the DPS made by the original acquirer.
Yeah. Can promoter of target company give competing offer? What if he is economic offender?
Economic offender is definitely not allowed to make any offer at all.
And if otherwise?
Yes, they can.
We can. If he is not an economic offender, he is not prohibited. But if it is an economic offender, he cannot.
Yeah. Okay, fine. Then we answered all the questions. Now, Jasveen, you can go ahead.
Yes. So the three types of takeovers are friendly takeover, wherein the board of the target company is comfortable with the takeover and they do not object the takeover. Second is a hostile takeover, where the board of the target company prevents and tries to block this takeover and they're not comfortable with the acquisition. And last is bailout. Bailout means when a financially strong acquirer acquires a relatively not such a strong, financially strong company, that is, or rather a sick financially sick company. That is referred to as a bailout. So past hostile takeovers that have taken place in the Indian perspective. First one, like we already discussed, Swaraj Paul had made a bid for Escorts and Delhi Cloth Mills, DCM. This failed because of various reasons, political and otherwise regulatory reasons. They blocked this acquisition, hostile takeover rather. But this was a big wake-up call for all regulators in India to prevent or kind of make sophisticated regulations.
All this SaaS regulation has actually emanated only after this particular
yes
acquisition which came into place.
Yes. So it was a big wake-up call.
Yeah, that was the beginning. Yeah.
Yes. ICI UK attempted to take over Asian Paints. One of the majority shareholders of Asian Paints had agreed to sell the shares to ICI UK, but for regulatory reasons, specifically, they did not receive the RBI nod, because of which this hostile takeover had failed. The first successful hostile takeover was by for the shares of Rasi Cement by India Cements, where Mr. B.V. Raju, who was one of the majority shareholders of Rasi Cement, had sold 32% of his shares in an agreement to India Cements. Did this hostile takeover did go through? And the fourth one is when Dalmia Dalmia Group tried to buy Jesco, but in this case, Mahindra acted as a white knight. That is, they helped Jesco in acquiring back its shares, due to which Dalmia was not successful in making the acquisition. A very recent one, hostile takeover, it was quite in the news a few years before, was the acquisition by L&T, where they acquired Mindtree. It was a successful acquisition by them, and it was the first big listed company that was acquired in the Indian perspective.
Jasveen, have you, for any particular reason, kept acquisition of public sector undertakings under the government's divestment plan out of this? Like, for example, VSNL and or Air India?
Yes, but actually that is again subject to a lot of requirements. That is why. But if there are any specific discussions about that, we can take that up.
No. No, since you have listed a variety of types of takeovers, I thought that is...
No, that is not taken over here.
That is not taken over.
This is majorly the hostile takeovers in India.
No, there are a number of exemptions there because it is government owned undertaking.
Yeah, because
absolutely.
It is because of the government regulator can give a lot of things, concession and other thing and all. That is why it has gone through. Very recently in Vodafone, it has happened. She already.
But it is a type of a takeover, so I thought it could have come into this.
Yeah, that is right. But these are all special circumstances, so we are not taken. But she touched upon the Vodafone government.
Yeah. I'm saying that because I've done that, no? Yes.
Okay. Yeah.
So if you have certain experiences to share in
that, you can share.
I'm an old man now. I don't remember. It's several years ago. Okay. There were a lot of good experiences, but then I have to put my thoughts together and all that stuff. Anyway, go ahead, please.
Okay, so what are the defense strategies that can be adopted by the target company to prevent a hostile takeover? One is Pacman defense, wherein once the acquirer starts acquiring substantial shares of the target company, the target company itself goes ahead and makes a counter offer for the shares of the acquirer. So in this case, if the target company itself holds a strong position, they can acquire the acquirer itself. Second is crown jewel. Crown jewel is when the material assets of the company that attracted the open offer are sold by the target company and its board. In the Indian perspective, it is quite restricted because a special resolution is required during the offer period to sell or alienate any of the material assets. Third is to buyback, when the shares that are available in the market are withdrawn and called for by the promoters of the company. That's a defense strategy. Fourth is golden parachute. What is this? They ensure that there are terms and conditions in the agreements, that if there is a takeover and the management of the company is has to go away due to a takeover, pursuant to a takeover, then in that case, high compensations are required to be paid to the management of the target company, which makes the target company unattractive. Shark repellents, special conditions in the AOA or bylaws of the company, of the target company, which ensures that if any takeover hits in, then the board prevents the target company from being acquired. Now there can be a variety of terms for it, one of which can be compensation for it, premium to be paid to the shareholders, etc. White knight is basically, we can call it in the plain language as the friend of the target company, who helps the target company in giving a counter offer or a competing offer in case of an open offer process, so that the target company retains its own shares. Reliance had acted as a white knight to East India Hotels to prevent them prevent a takeover of EIH by ITC Group. Greenmail is when the target company, the board of the target company sits down with the acquirer and negotiates for its own shares. Of course, this would lead to them buying the shares of the target company at a much higher price, which would be a financial burden, but this is also one of the defense strategies. Poison pill is when the board of the target company issues equity shares with special voting rights and issues it at deep discounts to ensure that their shareholding increases to prevent the acquisition. This was done by Netflix in the international perspective and by Saurashtra Cement as well to prevent hostile takeovers. Last is the disclosure requirements required to be made under the SCST regulations. Three kinds of disclosures that are required to be made. One is event-based disclosure. Second is continual or an annual disclosure. And the third is disclosure of encumbrance.
1 minute. There is questions. Mr. Poham has asked, since we are on the topic of hostile takeover, could you briefly draw some parallels with that of US perspective? I was fascinated as there seemed absence of strict regulation when there was an attempt to take over of Twitter. Mr. Amit, your view?
So, Dipti, I don't know a lot about US takeover regulations, but I think here you are talking about the Elon Musk and the Twitter related thing, right? So, can you kind of elaborate what exactly is your query here?
Mr. Soham, yeah. Can you unmute?
Good morning. Good afternoon, sorry.
Yeah, hi, Soham.
Yes, sir. So I was wondering if there are any strict regulations as that of the takeover code in India. Like we can see that in every step of the way, there are some regulations, some rules, like even if there is a change in percentage, like 1% acquisition or 3% acquisition of shares, like creeping acquisition, as we have seen, there are some rules and regulations in place. But in the US scenario, as I was looking at the Twitter case study, the valuation and all the valuation of the company and everything that the hostile takeover was going to be taken place was seemingly smoothly, like there was no deterrence by the regulators for the takeover.
No, so here also, if you look at it, as I was talking in the beginning, in India, there is no deterrence as such. There is no stoppage as such, which says that you cannot kind of take over a company or you cannot do a creeping acquisition. There are a lot of cases of creeping acquisition. There are cases of hostile acquisition as well. I think the only thing Indian regulation says is a disclosure, right? And at some stage, when it reaches to a level where you are going to acquire control of the entity, it requires you to give an exit opportunity to the shareholders who are there. So apart from that, there is no bar as such to say that you cannot do it, or there is any interference from the regulator where you need to go and take approvals of the regulator. If you see the whole process which has been explained so far, there are two things. One is a disclosure requirement where you go and simply disclose that I have acquired. Other is to say that now I'm kind of going beyond a particular limit. I am offering shareholders to come out of it. So it's not like a regulator can put a complete stoppage to your you bid as such, unless like there are certain serious economic issues, there are certain national interest issues that are there. That's a very separate scenario. We are not talking of that. But in normal scenario, if you see the scheme of our takeover regulation as well, it is more from an intent of transparency. It is more from an intent of protecting shareholder interest. It does not say that I am sitting there and I will do a judgment and decide whether you can take over a company or not. At the end of the day, it is a pure commercial business decision between two entities, whether they should kind of get into this business or not, and shareholders has a right to at that time exercise their choice. So not very different, by the way, than what you are seeing in the US scenario as well. I hope Somam answered your question.
Yes, sir. Yes, sir. Thank you so much. It gave me a lot of clarity in that matter.
So basically, here the regulator doesn't want to interfere in the business of the company at all. You run the business, there is no problem. But only thing is, do two things. One thing is, make a proper disclosure to the owners of the company, which is the shareholders. Second thing is, you comply with the requirement, whatever is there, do that. That's all. Beyond that, they are not having anything to stop, or they are interfering in the business decision, nothing like that. Nowhere. Same place with the other countries as well. Whatever you are saying. Yeah.
Okay. Thank you. Okay, Amit, there is another question. It's addressed to Mr. Venkat. Is there anything in the takeover code at all on evaluating the creditworthiness of the acquirer to safeguard the interest of the acquiree shareholders? One other question is in respect of what Mr. Bhasin has remarked on management philosophy. How many boards will reject a pricey takeover citing difference in management philosophy? How can one evaluate the management philosophy, as it seems more subjective?
Yeah, so I will pick up the later part of this question first. As we said, one of the requirement here is the views of the independent directors to the shareholders on an offer. Now, the way in an ideal world this has to work is that the executive board should not be part of it, which means any vested interest is out of it. The independent directors has to evaluate the overall offer from a point of view of long-term interest of the company, whether this offer is going to kind of promote the company further and the ambition that is there. Secondly, whether the interest of shareholders is going to get further enhanced, whether there is a value creation that is going to happen or not. And thirdly, I think from a philosophy point of view, and it's important, as I said, from a philosophy point of view, it's important to find those synergies that is there. You're right in saying that management philosophies is subjective, but that's not the only decision or the only reason how the independent directors give their opinion. When they give their opinion, they take into account a lot of things. One of the things, of course, is the philosophy of the new promoter, which is coming, what is their way where they want to see this business as. And based on that, the independent directors who are sitting on the board give an opinion saying what we see, how the current management is running the business, and therefore what we see how the new management which is going to come are going to operate, and then they give a independent view to the shareholders. As I said, it is in, I'm talking from an ideal word and from an intention point of view, and I was having this discussion with Mr. Bala as well, where he said, do you really think it happens that way? It is supposed to happen that way. Let me put it like this right now. And we talk about corporate governance and we talk about independence of directors. I will stay away from that question of saying that whether directors are actually independent and the view is actually independent or not. But purely from a control point of view, why this provision came in the law was this, that the independent directors who are sitting on the board for a long period of time understand the business well. They are better equipped to give a independent decision or independent view to the shareholders to say whether they should go with the bid or not, right? There is nobody else who is better equipped. The shareholders are not handling day-to-day kind of conduct of the business. So that's the reason, in an ideal world and from following the governance norms, if this works, this is the best tool, I think. And again, from my experience, I have seen this happening. Independent directors exercise a lot of judgment. They take independent views. They take views from lawyers. They take views from economics wherever required, economists wherever required. They make a holistic case and then give their view, because at the end of the day, it is their report which is going out. It is being signed by independent directors. Tomorrow, in a US scenario, there could be a class action also against the company if there is something that goes wrong from a valuation point of view. So I think there, to put it a little crudely, I think they have putting their neck out while putting their opinion, and I think it becomes responsible for them to therefore exercise due diligence and give their opinion. And as I said, management's philosophy is one part of that decision making which may be considered. Now, coming to your earlier question on credit worthiness, I think Jasveen explained in the process that some of those controls are built in already to ensure that it should not happen that you are making an offer but you don't have money to pay. So I think those controls are already built in the process of takeover code to ensure that if shareholder decide to tender the share, they will get their money. So I think the credit worthiness and the ability to pay shareholders is built in the provision itself.
Yeah, on the escrow account and then
Yes.
Yeah.
Without getting into any of the controversy, I would like to say, yes, as far as the independent directors are concerned, in a good governed companies, yes, as Amit puts it, it is a reality, it is working. But majority of other companies, which is otherwise, it is reality is something different.
Okay, there is a question from Mr. Samir. If disclosure is not made, would that attract criminal liability?
Particularly in the past cases, I don't think there has been a criminal liability for it, but they have charged, asked for fines, interest, etc. But not, they've not criminally prosecuted.
Criminal liability will not be there unless until it is done with the intention of the fraud, etc. But the penalty provisions are already there.
Yes.
Okay. Okay, we have then answered all the questions. Jasmine, you can go ahead with the presentation.
Yes, last part of the presentation is the disclosure requirement. 3 types of disclosures that are required to be made. One is event-based disclosure, second is the annual continual disclosure, and the third is in relation to encumbrance in the shares. So certain principles before we, for the disclosure part, before we go ahead with each disclosure discussion. Disclosure is required to be made of the shareholding and voting right. To be noted is control is not covered over here. So it's only for the shareholding and voting rights of the acquirer, promoters, and persons acting in consort. For the purpose of this disclosure requirement, convertible securities shall be treated as shares. Encumbrance for this purpose means any restriction on the free or marketable title of the shares. It can be in the form of pledge, lien, negative lien, lock-in requirement, or pursuant to any agreement entered into by the company. What is essential is there should be a restriction on free and marketable title of the shares. And an obligation on the stock exchanges is whenever they receive a disclosure under this regulation, they shall immediately disseminate it to public at large, with the intention that everybody should be aware of the shareholding in the company. First is the event-based disclosure, regulation 29, which says if any person acquires shares or voting rights, which together with his current holding entitles him to 5% or more of the shares of the target company, he shall give a disclosure in this respect. Second is for a person who already holds 5% or more, if there is a change in the shareholding of such a person by more than 2%, then he has to give a subsequent disclosure. For the purpose of these regulations, shares taken by encumbrance is treated as acquisition, and shares released from encumbrance shall be treated as disposal. However, this shall not apply to scheduled commercial banks, public financial institutions, housing finance companies, and systemically important NBFCs. Due to the nature of their activities, creating encumbrance is quite an ordinary course of business for them. So let's understand certain illustrations for these regulations. So let's suppose Mr. A acquires 4% of shares of a listed company, ABC Limited. No disclosure shall be given. If he acquires 6% of the shares of ABC Limited, he shall give his first disclosure under 29(1) since he meets 5% requirement. If Mr. A already holds 3% of ABC Limited and goes ahead and acquires 1.5, making his total shareholding of 4.5%, which is less than 5%, no disclosure is required to be given. But if he holds 3% and further acquires 4% of the shares of ABC Limited, making his aggregate shareholding to 7%, which is more than 5%, he has to give his first disclosure under 29(1). Illustrations for 29(2), that is when you hold 5% or more and there is a change in the shareholding of more than 2%, then in that case, let's say Mr. A holds 6% of the shares and he acquires 1.5% shares of ABC Limited. No disclosure requirement since it is less than 2%. If Mr. A already holds 6% and acquires 3%, being more than 2%, he will be required to give a disclosure under 29(2). Now, if Mr. A already holds 10% and sells, since the word used in the regulation is change should be more than 2%. So even if he sells his shares of ABC Limited, he shall give a disclosure under 29(2). Last scenario, if he holds 10%, Mr. A holds 10% and he sells 6%, so his total shareholding becomes 4%. But he shall still be obligated to make give the disclosure under 29(2) since there is a change of more than 2%. This disclosure shall be given within 2 working days from acquisition or disposal as the case may be, and disclosure shall be given to the target company and every stock exchange where the shares of the target company are listed. Continual disclosure, every person with the person acting in consort who holds 25% or more of the voting rights, and every promoter of the target company, irrespective of the percentage of voting rights, shall disclose their aggregate shareholding as on 31st March of every financial year. When shall this disclosure be given? It shall be within 7 working days from the end of the financial year. Again, this shall go to the target company as well as the stock exchange where the target company is listed. Disclosure of encumbrance. This is an obligation on the promoter only of the target company. The promoter shall disclose the shares that are subject to encumbrance of the target company. And if there is invocation or release of encumbrance on the shares of the target company, a disclosure shall be given for the same. The timing is 7 working days from the creation, invocation, or release of the encumbrance. Apart from this, the promoters have to annually declare that no encumbrance other than those already disclosed during the financial year have been created or invoked or released. This disclosure shall be given within 7 working days from the end of each financial year. So we come to the concluding part of this session where if we have seen the entire takeover regulation, it is quite a sophisticated regulation that has been issued by Sebi, and quite a holistic one there where they have ensured all kinds of safeguards for both the acquirer as well as the target company, but more importantly, what they have ensured is the interest of the investors shall be protected at all times. Yes, with this we come to the end of the presentation.
Lovely
Excellent,
presentation, Jasveen. Lovely presentation.
Excellent.
Very detailed. You showed deep knowledge of the subject, and it was really nice listening to you. Thank you.
Thank you so much, sir. Means a lot.
Excellent, Jasveen. Very nicely presented, made it very simple, explained very nicely. Your loose in language, simplistic English with examples, etc. and other thing and all. Really, you have done a wonderful job. I accept my appreciations.
Thank you so much, sir. Thank you.
But now, having made such a wonderful presentation, you should do something with Sebi to specifically introduce an exemption on the matter which I talked about. It should not be left for us to interpret. You know, if the shareholding goes beyond 25% because of that rights issue thing, as I explained,
Yes.
it should be specifically exempted the way you have got for the other one. 90 days. Within 90 days, you bring it back.
That's right. That's right.
So,
Yes.
so Sebi should be approached, and Mehta should take a lead in that.
Yes.
Such a good panelist who is involved so high level. So he can also take it. There's one question. Is there any threshold limit for making disclosure for encumbrance?
No, there is no threshold limit. Any encumbrance has to be reported.
Yes, any encumbrance. There is nothing limit or something like that. Anything.
Okay.
My sincere thanks to Amit also for sharing his excellent knowledge. We are really benefited his practical experience from national and as well as the international level. Many of the insight things from him.
Yeah.
Thank you.
It's a really a learning process actually.
Yeah, Amit, we require more your knowledge sharing, and I think participants will agree that your knowledge is so vast it will help all other participants and the CS in the practical life of implementation. Thanks a lot, Amit, for your time and sharing your knowledge and experience with a full heart. Thanks a lot. Thanks, Amit.
Thank you, everyone. Thank you.
I become 20 years younger. Because I had done 1997 takeover code. With Amit, I could also learn with Jasveen's help also 2009, various changes. What has come, various development which was taken actually, really speaking, as Silent Boy will agree, we are all in the process of unlearning and relearning. So
and forgetting.
Not forgetting. That is not. Not yet. I have not reached that
Not
stage.
you yet. Not you yet.
I have not yet reached
I
that
very much
stage.
so. I very much so.
Maybe.
But again, Jaspreet, lovely presentation. Again, I am repeating. Lovely
Thank
presentation.
you so much, sir. Thank you.
Thanks, everyone.
Thanks, sir. Thanks a lot.
Not only that, you have maintained excellent time also. Time limit also you have maintained. That is very much appreciated. It is
I made a
exactly
promise to Amit sir for that.
Yeah.
I keep my word.
It is exactly 1 o'clock now. Thank you.
Thanks.
Time management is very important. Yeah.
Yes.
Thank you.
Bye, everybody.
Thanks.